This is Michael Popok, Legal AF After Dark. You may know the podcast, but you don't know the clip I'm about to play you, and that's from the midweek edition. Karen Friedman Agnifilo and me, Michael Popok, we start talking, her from the prosecutor perspective, me from the defense lawyer perspective, about something interesting that happened at the intersection of law, politics, and justice this past week. In particular, the D.C. election interference case brought by Jack Smith, presided over by Judge Chutkan. For instance, we discuss, will she continue the stay of the gag order, or will she reimpose the gag order? As you can tell, even after dark, New York doesn't sleep. Will Judge Chutkan adopt the position of the Department of Justice, reimpose the gag order? What's going on with the 4 different motions filed by Donald Trump as a last gasp effort to get rid of his indictment? Watch now as Karen Friedman Agnifilo and I talk about, analyze, and debate these very issues. But let's talk quickly about what's going on in Judge Chutkan's case.
Speaking of presidential immunity.
Yeah, speaking of presidential immunity, we got Judge Chutkan, who's presiding over the case that is going to trial, come hell or high water, as Judge Engoron likes to say, in March of 2024. She's made that clear in at least 4 times, including a week or so ago, that she is not delaying the case, that the electoral calendar and when he's debating or not debating or when he's primaries, no concern to her. The case is going to trial. It's a relatively straightforward case going to trial. 1 defendant, Donald Trump, 4 conspiracy counts. That's it. We're going to trial in March. And so Donald Trump, then fired back with, well, let me file 4 different motions addressed to the indictment. He only did it to get around the page limit.
I was just going to ask because each one was like 35 pages or something.
Yeah, here they are. And so that everybody knows, when you file a motion in federal court, there's a page limit, unless you get it by the rules, unless you get an enlargement from the judge. So rather than do that and make 1 big motion, they decided to do 4 motions, so they get 4 motions and 4 reply briefs and whatever. They're all ridiculous. When you start with the motion to dismiss the indictment based on statutory grounds and a memorandum in support, and you look at it, it's just 30 pages of repeating the argument that Donald Trump is being prosecuted and indicted for his speech. And he has the right under the First Amendment to say that the election was false or fraudulent or stolen from him. But that's not what and nowhere in there, like if you and I really believe this argument, if you decided to practice law with me instead of Danya, okay,
you didn't ask.
All right, okay, all right. Well, we'll talk offline. We make a chart. We make a chart of all of the overt acts and other acts of the conspiracy, and then we would match it up with First Amendment speech. We say, this is nothing more than speech. This is speech, and this is speech, and this is speech. The reason they don't do that is because the indictment has nothing to do with speech. It's not his belief system. It's not thought police. It's not things that he says. It's things that he does. It's the conspiracy to overthrow democracy and stop the peaceful transfer of power, and the acts and steps that were taken by him and a dozen other people at his behest to accomplish that. That you're not allowed to do. You want to get up like a crazy person and stand on a subway platform and yell out Donald Trump won the election. You're allowed to do that. No, no one's going to take you away for that or criminalize that. But you, in the face of the only reason we talk about whether he believed or didn't believe that he won or lost the election is it goes to mental state. And we need to prove as a prosecutor, or the prosecutors need to prove mental state, criminal mind, mens rea, intent, willfulness, corruptly, whatever the actual standard is for the particular crime that's been charged. And the way you do that is to show there is nobody who objectively, reasonably, that's the standard, under the information outflow that was coming at Donald Trump from credible sources, no one could have reasonably believed that he won the election. No one. I'll give you an example. In his brief, this other one, which is very, very similar, called Motion to Dismiss the Indictment Based on Constitutional Grounds. This is my favorite part. There's so many favorite parts, but we only have a limited amount of time. He says in here that, listen to this, Karen. he says that this is all about viewpoint discrimination and criminalizing speech. And they go on to say, this is especially true because claims that the 2020 presidential election was rigged or tainted by fraud and irregularity does not involve easily verifiable facts. Wait, it gets better. Such claims require the assessment of mountains of information from which each person will draw competing inferences based on facts as well as their personal, deep-seated political views and presuppositions. They are not readily verifiable or falsifiable. They relate to politically charged issues, and people's assessment of them is linked to their political predisposition and their trust in institutions, including governmental institutions. Okay, let's stop right there. The facts that the 2020 election had no fraud that was outcome determinative is a verifiable fact. And don't take my word for it. Take Chris Krebs, the head of the Cybersecurity for Election Integrity Department that Donald Trump fired, Attorney General Barr, White House counsel Pat Cipollone, Deputy White House counsel Eric Hirschman, acting Attorney General Jeff Rosen, and outside forensic auditors hired by Donald Trump who reported directly to him after he paid them $1 million that there was no outcome determinative fraud in the election. To say that this gobbledygook, that facts are subject to interpretation and you could still hold the belief that there was a fraud case, and then point to polling, which has all been skewed by Donald Trump continuing to say it over and over again, and say, see, 60% of the people think there was fraud in the election. Who cares about polling that you ginned up with your own position? But this is their entire point. That he is not lying. He just has a difference of opinion about whether there was fraud in the election. Okay, two things. One, that's bullshit. There was either fraud in the election or there wasn't. And every reliable, reasonable source, all ignored on purpose by Donald Trump, told him in real time that none of his false theories held any water. There weren't dead people voting. There weren't absentee voter fraud with signatures that were missing. There's always, let me just say this, there's always fraud in the election. There's always somebody who votes their dead mother-in-law's ballot. There's always somebody that votes in the wrong precinct, either intentionally or not intentionally. There's always somebody who votes twice. They did a mail-in ballot and they feel like going on election day, or they forgot they did a mail-in ballot. It happens. 0.002% is what it happens. That's the statistics, because we know it, because we're now 3 years later. Okay. And so that does not overturn 7 million votes or votes in each battleground state that determined the election. And so for Donald Trump to say two things over and over again with no proof and no evidence, three things: Joe Biden is out to get me, and there's proof of that without providing any proof of that. Two, there is no facts that support that there was no fraud in the election. That's a lie, and we know that. And three, I'm being prosecuted for First Amendment speech, not conduct. The reason they never talk about conduct, right, is because they know that they die on that hill, right? This is my favorite intro here, Karen. This is on page 2. Attempting to explain this obvious contradiction, the prosecution argues that there was no outcome determinative fraud in the election, whatever that means. I mean, stop right there. What do you mean, whatever that means? It means there was no outcome determinative fraud. There was fraud. There's fraud in every election. It doesn't change the results. And that President Trump supposedly knew this because some government officials notified him. Some random government officials, Bill Barr, Pat Cipollone, the head of the Department of Homeland Security, the head of Cybersecurity for Integrity in the Elections, Jeff Rosen, Eric Hirschman, just to name a few. The fact that he decided to gin this up and rely on indicted and now convicted lawyers who told him what he wanted to hear, that there was fraud in the election, doesn't mean that the prosecutors are out to get him, are selectively prosecuting him, are vindictively prosecuting him, or that he's being put in jail ultimately for his First Amendment speech. All of these are, I want you to talk about the ones you want to talk about. All these are going to be rejected after full briefing by Judge Chutkan. It'll go to the DC Court of Appeals. That'll get rejected. It's not going to delay the March trial, I assure you. And that's it. I'm done. I'm out of here. I'm going to storm out like Donald Trump. I'm gone.
So I'm going to confess.
Okay.
I'm going to confess something.
Okay.
When I was prosecutor and I was a trial lawyer, used to try cases in state court, in New York State Court. For summations, it's not like federal court where the prosecutor goes first and then the defense attorney goes and then the prosecutor gets to rebut what the defense attorney says. In state court, the defense attorney just goes first for the summation, and then you get to go after as the prosecutor. You get the final word. You go first, and you get the first and the last word. You go first for the opening statement, and then they go second, and then it's the other way. Every single case, no matter how strong it was, no matter how much my witnesses did great, evidence went in as I wanted it to. After every defense summation, I would need to go to the bathroom and cry, because it felt like, oh my God, how am I ever going to overcome what they just said? Like, I can't, they just pointed out all the problems and all they need.
I love this confession. I've thrown up before trials. I'm with you.
I've never done that, but but I literally would have to just like go in, take a deep breath, because beyond a reasonable doubt is you just need a little bit, and you need to convince one person, and then you don't get a conviction. And I'd have to remind myself of what the facts were and what the evidence was, and then you got to get yourself to go together, and you go out there and you deliver it. But it was that feeling, that punch in the gut, that sick feeling. And I will say there was one argument in these motions that gave me the same feeling, and it made me kind of sick. But again, this is before Jack Smith has responded, and I can't wait to read the response and see what he says, because I'm sure he'll make me feel better, just like the summation. And the reason this one argument concerns me is because the ultimate audience is the MAGA Supreme Court. And this feels like something that the MAGA Supreme Court ultimately, if it gets to that point, it might perk their interest. And it's the double jeopardy claim that was made in this series of one motion split into several to avoid the page limits. And in the double jeopardy motion portion, Donald Trump argues that the text of the Constitution says that only a party convicted by the Senate may be then later charged by indictment, trial, judgment, and punishment, not a party acquitted. And the Senate acquitted the president when he was impeached, and therefore he cannot be retried in court. Then they go on to cite the Federalist Papers and Nixon v. Fitzgerald. And I just...
The acquitted, wait. The acquitted language isn't in there. They make the position that the acquitted language, it's not in the text. The convicted is in the text.
Right, exactly. Yeah, they say, therefore, because he's not convicted, it goes to, whatever. That's the one thing that I worry that the Supreme Court, the rest of it, I agree with you. It's conduct, it's clear conduct, it's not protected speech. But the fact that he was impeached by the House and then acquitted by the Senate worries me a little bit, that the Supreme Court could potentially view it like this. But I want to hear what Jack Smith has to say.
Well, I have an opinion. I'm not Jack Smith, but I have an opinion. But I have a very similar thing, but not on the summation. Whenever I get a brief, from a good counsel on the other side, I start reading it my first reaction is maybe I do have the facts and the law wrong here. If this, it could be very persuasive. And then you take a deep breath and you go through it and you're like, wait a minute, this fact is wrong. This is not what the case says.
Yeah.
That's not what the case says. The whole analysis is wrong. I was not as concerned as you are by double jeopardy because that's not how I read that. The way I read that is that the Senate and the impeachment process has a role. And that role is, and the only thing that's relevant here that he was tried on in the Senate without witnesses, if people remember, the Democrats who were the House managers, who were the prosecutors, had to make a decision because we were already in like February of like 2022. He was already out of office for a while. They had to make a decision in order to get McConnell to move the trial, to get the trial called, to dispense with witnesses. They were going to put on new witnesses. They just said, well, forget the witnesses. We'll submit the transcripts from what happened at the impeachment level in the House of Representatives, and we'll just do statements. We'll do opening statements and closing statements, closing arguments. So they got there. So there was a trial, but it was only on whether Donald Trump was responsible for the Jan 6 riot.
Right. And he wasn't charged with that specifically.
And he wasn't charged with that, which is back to my internal inconsistencies among the 4 pieces of paper. I know Laura wrote. I wonder
if that's why Jack Smith didn't charge him with that.
Maybe. And I wrote in my little notes, that's why Jack Smith didn't charge him with that. Because,
you know what? There you go. That's why. You're right. I bet you're right.
Because Jack Smith used it to say we were upset when we read the indictment because we were like, we know he's responsible for the Jan 6. Why didn't he say that? And even the Jan 6 committee said that, right? Because Jack Smith he said it was used as they took advantage. Donald Trump took advantage of the chaos of Jan 6th as part of his, but it wasn't laid out the way the Jan 6 committee. Remember the Jan 6 committee had like the 7 links in the chain? The 6, and the last one was, when all else failed, when the pressure campaign on Mike Pence failed, when the attempt at the fake electors failed, when the attempt to intimidate state legislators and elected and election officials failed, when all else failed, they lit the match, pointed the gun at the Congress, and sent in their angry mob. That's not how Jack Smith put it in his indictment. And now maybe it's because he was concerned about the double jeopardy issue. So I'm not concerned. First of all, the way I read it, it's an impeachment issue, not a crime issue. Even McConnell said, that's why we'll have criminal courts if there's really a crime here. They can go up. Right. But there's got to be a reason. I think you just explained it. There's got to be a reason that Jack Smith went a little bit off script when it came to describing the Jan 6th itself, insurrection, when he wrote the indictment. And
if that's the case, genius.
I know,
right? But what a just genius. Talk about a high level anticipating this argument and analyzing the impeachment and not including it. I mean, he is playing ball on a level that is it's just so impressive.
I wrote it. Now nobody can read this. But I wrote, not only is it internally inconsistent on the Jan 6 issue, but I wrote when I first read it, right, and that was not included in the prosecution, in the indictment. So listen, I think that I'm reading something from our producer. I agree, Paulty. People will know what I'm agreeing to later. Yeah, look, that is genius, and I don't think anybody else has been talking about it. Not to twist our shoulders out of our sockets to pat ourselves on the back, but I love when something like that happens. There you have it. If you've never watched Legal AF before, that is just your appetizer. The entree is coming every Wednesday and Saturday, 8 p.m. Eastern time, right here on the MeidasTouch YouTube channel. If you don't know about us, welcome. If you know about us and you want to get another friend to know what you're talking about when you talk about, I just saw or heard something on Legal AF last week, show them this clip, show them this hot take, and help them come over to the light, as we like to say on the MeidasTouch and Legal AF side here. We sit at the intersection of law, politics, and justice, so you don't have to. And we debate these issues out in the open with 3 leaders of Legal AF, Ben Meiselas, Karen Friedman Agnifilo, and me, Michael Popok, collectively with 75 years of experience. Until my next Legal AF, until my next hot take, This is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.